Welcome to the Seven Figure Leaders podcast. This podcast was created to celebrate the success stories of seven-figure business owners, giving them a platform to share their insights and lessons learned in order to inspire other business owners. As well as that, it's an opportunity to build new connections. So if you're a seven-figure business owner or someone who works with seven-figure business owners and you're looking for introductions to potential stakeholders, strategic partners and clients, I'd love to hear from you or have you on as a guest and see if I can help make those connections for you. Just go to synergycfosolutions.co. That's synergycfosolutions.co and click podcast. And there you'll find the link to apply. Today we've got Craig Kelly from Aqua Bridge Law, focusing on corporate law. How are you doing, Craig?
I'm fine. Yourself? Good. Yeah,
Yes.
I'm enjoying the weather at the moment. So yeah, it's nice to see the sun shining for a change.
Yeah, it's lovely. It's lovely. Yeah, pleasure to have you here.
Thank you for having me. Thank you for the invite. Much appreciated.
So, best place to start. Why don't you give us a bit of a background as to who you are and what you do?
Yeah, so I'm Craig Kelly, as you said earlier. I'm a corporate commercial solicitor at Aqua Bridge Law, based in the Chelmsford office. So I assist business owners with anything from the start to the finish of their businesses. So incorporation and then any sort of documentation that they need during the process of their businesses. So terms and conditions, shareholders agreements, and also for exit. So dealing with the mergers and acquisition side if they're selling their business through a share or asset sale, and also deal with the purchasing if we're working for clients on that basis.
Okay, brilliant. And run us through how you kind of got to the position you're in now and got into all this.
It's a long process, actually. I graduated from university in 2008, so it's a long time ago now. But I sort of had a few different careers. I was actually working in university administration for a time, working with students and helping them through their journeys. And then I sort of come across what was called the Intellectual Property Institute, and that's where I got my background in intellectual property from, and sort of worked with them, and then worked for a large law firm in London, working in trademark law as a legal assistant. And then the big golden nugget of the training contract came up back home in Essex, so I took that, and now for the last 8 years I've been working as a corporate commercial solicitor. So it's been a bit of a long trip, but I've got there eventually, which is always nice.
Okay, perfect. So you talked about helping businesses all the way through. So from the beginning all the way through to the end. So why don't you give us a few examples of kind of the main problems that you see with business owners in terms of them not being protected in the way that they should be from a legal perspective?
Yeah, I suppose when you sort of have a limited company, it's always best to sort of have a shareholders agreement in place. That would be the number one starting position. I hear a lot of stories where, family and friends get into business together and it's all, we're great, no problem's ever going to happen, we'll be fine. We're just, we've been best friends for years. But I suppose sometimes that's when sort of the waters get muddied because of the issues and, because they get on so well. Having a shareholders agreement in place to sort of set out exactly the rules and regulation of how the business works is better for all parties, because then if, God forbid, there is an issue further down the line, then there is a template for them to work from. To say, for example, if they're looking to how they transfer their shares, what happens when a business owner leaves, because that's a huge issue, especially if you have two business owners where one really solely focuses on bringing in the business and one sort of works on the business. If there's no shareholders agreement in place, then effectively what could happen is they could take all of the customers and the clients with them to a new business if someone wants to leave, and it leaves the company effectively worthless because they haven't got anything in place. So if the shareholders agreement can place those restrictions on each shareholder to then ensure that the company has continuity if one of the shareholders is to leave. So that's definitely a main aspect.
Okay. And so can you give some more examples of what happens if those things aren't in place, or perhaps horror stories of situations that you've come across?
Yeah, so reiterating what I just said there, where you sort of where there's been no shareholder agreement in place. Two shareholders were friends from school. They went and set up their own business together. One really worked solely on the business, the numbers and the crunching and getting that sort of done, the actual work. And then the other guy was the person who had all of the contacts, the clients brought in the business. And he saw this as, well, I'm bringing in all the money, not, the other shareholder's not really doing as much as I am. Why can't I do this by myself? So things are not all turning out rosy. Effectively, then he set up his own business, took all of the clients with him, all of the business, and left the company that they had together effectively worthless because he'd taken all that. Now, if from the beginning, if they had a shareholder agreement in place, they could have placed those restrictions there to say that you're not allowed to take clients with you for a maximum, could be 12 months, 2 years, 3 years, and then it allows the company then to still be stable if another shareholder leaves. So having that protection in place can protect the company and the other individual shareholder who's going to effectively be left behind.
Definitely, definitely. And so yeah, I didn't mean for you to like repeat the whole thing. I actually
Oh,
meant I actually meant like other examples. So like let's say a disputes are obviously pretty common. And yeah, when you set up a business, setting up a shareholders agreement probably isn't the number one thing you think of getting set up. As you said, people are often friends or they're working with their family, or you just don't imagine a dispute to happen. But it's inevitable that every business is gonna end at some point, or every partnership is going to end at some point, whatever that looks like. And so yeah, perhaps some more examples of the types of disputes that you've seen. Let's say one shareholder wants to go in another direction, or disputes over how to run the business when they both got equal shareholdings in the company. I don't know, you take it whichever direction you want to go, but
yeah.
I imagine you've got a lot of stories that you could tell about situations where it's all gone pear-shaped.
Yeah, so for what you can also have in shareholder agreements, what's known as a deadlock provision. If you do have two shareholders and they can't make a decision about how they want to take the company forward, so therefore in the agreement you would have provision which is called the deadlock provision. To so usually it then would then bring in an outside party to say, look, if we can't reach an agreement for this, then you can either liquidate the company, they both go their separate ways, or they try and find a neutral ground so it works in the best interest of the company to say, look, we need to do this because of A, B, and C. And then that's what the individual then would come in. Usually, sort of an accountant or someone of a professional standard will come in to try and resolve the situation. So that's one way that you can have sort of a dispute resolution wise, as opposed to sort of having a dispute, the company ends and then that's it. So with the agreements in place, it's just trying to find a resolution. But if there isn't one, then it shows you ways that you can try and resolve that. And then if not, it's the death of the company, I'm afraid. And that's what happens. So we've seen that on many occasions where shareholders just can't agree to what they want to do going forward. And then it just takes to say, we'll just go our separate ways. And then that's how it ends.
Uh-huh. Okay. And so the other big things you talked about was a merger or an acquisition, and then an exit or a sale. So the main agreements there, I'm not a lawyer, so you correct me if I'm wrong here. Heads of terms and then a share purchase agreement.
Yeah.
So
So, yeah. Oh, yeah.
yeah, go on. Yeah.
Yeah. So the heads of terms are sort of a known. Will set out the agreement from both sides, and it gives solicitors and the team sort of something to work from for the template for your share purchase or asset purchase agreement. Um, Heads of terms are not legally binding unless it actually states in there if certain clauses are. So even if you set out a list of how the transaction is going to work, unless it is stated it is legally binding, then they're not legally binding. So it's just used as a template really to move forward. So just having a good set of heads of terms in place gives you a good starting point for the share purchase agreement or the asset purchase agreement, which is the next level. Then that's where all the details are put in there. So for example, the price, how the goods and assets will be paid for, etc. So that's what that deals with.
Hmm. And so yeah, heads of terms is the one that basically specifies what the deal is going to look like, commits the buyer and the seller to each other, as in they can't go and find other. Well, they can't. The seller can't go and find another buyer, and then an NDA basically. Yeah, that's what that.
Yes, an exclusivity agreement may be signed beforehand, like you mentioned there, that you know are able to sort of negotiate for a period of time while you're negotiating with them, and then the NDA, the non-disclosure agreement, is usually signed just before the due diligence process is undertaken, because effectively you are sharing information about the company which is sensitive. So having that NDA in place gives the seller a little bit of comfort that information is not going to be shared among people, which it doesn't need to be. It's just keeping within, and it's used for that transaction, because effectively, it's sharing clients, it gives you details of clients, staff, um, accounts, work. So it's very sensitive data. So having that NDA in place is a tick box to get right at the beginning before the DD process is undertaken.
Hmm. And so at that stage of it, heads of terms, what sort of horror stories have you seen there?
It really comes back to sort of, if then it changes further down the line when the SPA then comes onto my desk and it's completely different to the heads of terms, and then the other party will say, well, this is not what we agreed.
Yeah.
But then the forcefulness of saying it's not legally binding is then brought into play. Oh, that's not we. Oh, it's deferred consideration. It says here, but it's a different date to this and etc. Or the purchase price is amended. Because it's not legally binding, it's very difficult to then sort of enforce that, because unless it's stated, then it's not. So usually the clauses which are legally binding is the confidentiality clause within the heads of terms, saying, we'll keep this transaction, confidential between parties, etc. So that's usually the part that's legally binding.
Hmm. And then moving into the share purchase agreement, again, correct me if I'm wrong, but I think this is the most important one. And a client that I worked with, they were selling their business, and they weren't actually going to use a solicitor with the share purchase
Okay.
agreement. And the deal consideration, so the total amount that the buyer was paying for the business, included probably 30-40% of deferred consideration over a couple of years. And the seller said to me, is there a chance that I won't get paid that money? And I said, well, obviously it's going to be drafted into a legal document to essentially commit the business to paying you that money. And he said, oh, well, I haven't got a solicitor. And I said, okay, well, obviously that needs to happen. This was before heads of terms had been signed, so it wasn't as if it was too late or anything like that. So obviously we then engaged solicitors, and it made sure that everything was in there. But obviously that could have gone terribly wrong if somebody hadn't told him to engage solicitors and make sure that he was protected there.
Yeah, especially when it comes to deferred consideration, as you said, a proportion of the purchase price will usually be paid on completion, and then the deferred consideration will come at a later date. Now, if it's a limited company, which is the buyer, then the seller is at risk that the limited company, may go bankrupt and out of business. Effectively, then there is no money for them to cover. So, when we do act for, the buyers, no, when we act for the sellers, sorry, we would insist, maybe on a guarantor or a charge over the shares of the company. Therefore, that if we're unable to get the money from the limited company, then there is, say, a director or a shareholder of that company as a guarantor, which you can then get the money from effectively. You're just always looking for to covering yourself there. And that's where the issue would have come if he was worried, oh, how am I not going to get paid? That's how you sort of cover that eventualities. It happens a lot with commercial property as well, where a limited company will take a lease of a shop, but then the guarantor will be a shareholder or a director of the company to cover any unpaid rent, for example. So seeing it that aspect, it sort of runs parallel with that.
Hmm. And so, have you got any stories that you'd be happy to share about examples where somebody wasn't protected in that sale process, in the share purchase agreement, either from the buyers or the seller's side? The reason I'm asking you to go down the story route is because it's much easier for people to relate to a story than to hear all this legal jargon. And I know that because it's the same with my industry, where we talk about the finances and people's eyes glaze over. So we try and give stories to help people realize how it relates to them.
Yeah, sure. So, we're relating to deferred consideration. I think the main horror stories are seen when it comes to the warranties. So, what a warranty is, it's a promise from the seller to the buyer about issues of the company, so that the company's not in any litigation. It has no issues with its employees. It doesn't owe any money. So what happens is then you have what's called a disclosure letter. So if the seller cannot meet the warranties, then they disclose it in a disclosure letter and say to the buyer, look, there is an issue with the company, etc., etc. And then it's then for the buyer to think, well, is it worth the risk taking going forward to purchase the company? We had an issue in this a few years ago where no, the seller insisted the company was absolutely fine. There was no issues. And as the buyer said, okay, that's absolutely fine, take it on that risk. There was no disclosures regarding it. And then it turned out that there was a huge issue regarding a huge litigation matter regarding the products that they were providing. So it wasn't only money that they owed to the person, it was also the reputation of the company, because the products were faulty. They'd then not paid the money back. So these new shareholders, 6 months down the line, had taken on this company that had all this litigation against it and also damage to its reputation, and it wasn't disclosed. So that is one of the biggest issues when it comes to the SPA, especially as a seller, is ensuring that if you do have an issue and you can't meet those warranties, disclose them, and it's buyer beware. But if it's it's a huge issue, because if they have given the warranty, then that's the issue. So you can claim for a breach of warranty. So there is a remedy for that for going forward. But at the time, you've just bought a brand new company and you've been hit with this huge litigation that you weren't aware of. And not only the money, but the damage to the reputation of the business that they've only just bought. So that was one of the biggest issues.
It's like buying a house and then finding out that the foundations are collapsing in. And so what happens in that situation? How does the buyer claim on that? Or
Yeah, so then, well, like I mentioned, that it will then move to a litigation department, because I'm a non-contentious solicitor. I'm not into the litigation and this sort of thing. So non-contentious, they just argue over the contracts that we produce. So, and then that's when the litigation would be involved, and then a claim for a breach of the warranty would then be brought, and then that's where it would be decided, and then they would claim for any damages or loss to the business due to the breach of the warranty.
so they would claim against the business that the seller is now no longer anything to do with. So the seller's sailed off into the sunset, and then
Oh, it would be the claim against the seller, yes. So it would be because they are giving it on behalf. Yeah, so that's what it would be. Yeah, yeah.
and they would have would they have insurance, or would it be a personal claim?
Yeah, so this is it. That they may have something in place for, because there are types of insurances that can cover breach of warranties and this sort of thing. So it would all be based on that. So there would be a long process of how they would be claiming for that. So it would be, I said it'd be personal or through the insurance. Yeah.
Okay, great. And so we've talked about the shareholders agreement, heads of terms, share purchase agreement. What else? What else do you do for your clients?
So I mentioned earlier that I used to intellectual property, so dealing with the branding, trademarks, copyright in relation to the company. So what we can do, I assist clients with if they got a brand new brand or logo, slogan that they're looking to bring into the company. So we can work on that to get it registered as a trademark. So you then have 10 years protection to use that brand for yourself, and no one else could copy that. So horror stories for that example is a company spent thousands of pounds on a brand new brand that they brought out with the logos. It'd all been on their shop front, etc. It'd all been their logo pamphlets. That's when it was back in the day when it was popular, using leaflets. And I think they spent about £10,000. They then went to market on Facebook, and another company contacted them and said, "This is our name. We are the name of the shop. You are just effectively taking this. You're going to have to stop trading at this." And they came to us too late. They came to us and said, "Oh, we're in a bit of an issue." We had a look online. Yet they had the other company had a registered trademark, and they had to stop using the name. So just about that little due diligence beforehand, before they went into the branding and picking something, is something which really should be taken into consideration. And that's what we can help clients with, just sort of giving them, holding their hand through that process to say, this is what's already registered, and then thinking of ways that you can maybe change your logo or the slogan to be able to have it for yourself, but not infringing anybody else's intellectual property rights.
Okay, makes sense. And so how do you actually get your clients? Is it mostly through LinkedIn or referrals?
Yeah, a bit of both, really. LinkedIn, as you know, I post quite regularly on LinkedIn
Yeah.
and sort of stories, and so I'm trying to put some information up there to try and relate to business owners. And yeah, well, I've been very successful in retaining clients from there, and also repeat clients and referrals, and also in-house work where someone's working with our private client team and they have a business. So that's like wills and probate and things like that. And then they need some help with their business. So that work sort of comes across from there. So all sort of a lot of revenue streams coming through. Yeah. So it's good.
Okay. And so are there any tips that you'd have for a small business owner if they've listened to this and thought, I'm not legally protected in the way I should be? Anything that they can do, or is the only way that they can do it by kind of speaking to someone like you? And if so, how do they do it? Yeah. And are they welcome?
Yeah, so small business owners, so sort of it really starts from the beginning to the end. Is, if you are setting up or you're a new business owner, make sure that your branding is there and can be protected, and make sure you have something that stands out and isn't infringing on anybody else's rights. Um, for between the shareholders, have a shareholders agreement or partnership agreement in place, so that how the company is governed and how all the shareholders need to work to make sure that the company's processing correctly. If you're dealing with providing goods and or services, make sure you've got good agreements in place to make sure that you're paid on time. No And if there are any issues with not receiving payment, then make sure that you've got good clauses in there to ensure that you can retain that money and get that back. And then if you're looking to then sell your business, just make sure everything's in place within, a good time frame beforehand, because sometimes that can really hold up the process if you haven't got all your documentation in place and nothing's there. So have a good set of accounts ready, have everything sort of in place and just ready for sale. And yeah, just have everything in place. I think is probably want of a better word, but just making sure that your paperwork's all in order to ensure that your business runs smoothly and you've got a good trail of, if there are any issues, then you can always go, oh, I've got this and I've got that. So that's what I would say.
Absolutely. Great. And so for anyone who's listening to this, who's thought, I need to have a chat with Craig, we'll make it very easy for them to do so. We'll put your LinkedIn link and then your email address as well. Does that work for you?
Absolutely perfect. Yeah, that's always good. Always nice to have a chat with people and see if I can help in any way.
Brilliant. Anything else you'd like to share?
Just thank you for listening and thank you for inviting me, Tom. That's great. Thank you very much.
Craig, pleasure to have you on. And yeah, looking forward to speaking to you again soon.
Cheers, Tom. Thank you. Thanks.
Cheers. Thanks for listening. As I mentioned at the beginning of the episode, this podcast was created to celebrate the success stories of seven-figure business owners, giving them a platform to share their insights and lessons learned in order to inspire other business owners. As well as that, it's an opportunity to build new connections. So if you're a seven-figure business owner or someone who works with seven-figure business owners and you're looking for introductions to potential stakeholders, strategic partners and clients, I'd love to hear from you or have you on as a guest and see if I can help make those connections for you. Just go to synergycfosolutions.co. That's synergycfosolutions.co and click podcast. On that page, you'll find the link to apply.